Jamaat and viewers, our next speaker is a lady, again practicing as an attorney since 2001, holds a B.Proc degree and then a master's in law, director of the Women's Legal Center, and she advances women's rights in a society dominated by men, board member of the Lawyers for Human Rights, a passion for women's rights, and a community activist. And she will be speaking on a very, very important aspect of today's conversation, the effect all this has on our wives, our mothers, our daughters, and our sisters. It gives me great pleasure to call upon Sehaam Samaai.
This. Yeah. Assalamu alaikum to everyone. It's wonderful to be here. Also from the Women's Legal Center. We have litigated on Muslim personal law for many, many years. And I'm here to be able to just give our experiences over the past 25 years on what happens either if you have a will or when you don't have a will. Sheikh Abdul Rauf has indicated that when there is a will and that you will be able to, in South African law, to be able to draft a will. That means that you have freedom of testation. It means that you've got a right to be able to put that which is required in the will and to be able to be distributed. But one of the challenges that we do have is that when there is no will, and you are in a South African context, and there are many, many scenarios that I can maybe give examples of, but the most fundamental is that if you die without a will, what happens to the women, what happened to the children, what happened to the heirs? Now, in South African law, if you die without a will, then automatically the South African law applies, which means South African law is rooted obviously in Roman Dutch law, etc., and it has its own distribution in terms of intestate to ensure that the children and the wives or the spouses, etc., they do at least access that which is in the estate. There are many reasons for that, because one of the challenges were first that women could not inherit. Secondly, there was also a very broad rule, which is the head of the household, and women are either left out of the will and children do not get the will. So over a period of time, this changed, and I think it's very important to speak within a South African context. Because South Africa in itself comes from an exceptionally patriarchal society, and women could not own property, or Muslim women that were married, that means specifically Muslim women married in terms of Islamic rights, more times than not, did not own property. The challenges is that when the person dies without the will, how does the distribution work? One of the first, and let me just explain, one of the legacies of our apartheid state was that there was a very particular ethnocentric policies which looked at Christianity broadly as the basis for distribution or also for the concept of marriage, which meant that spouse did not include a Muslim spouse. That had a major, major impact pre-1994. We had a legacy where, for example, there was the case of Sidat and Ishmael, which it provided a context where the cases deemed Muslim marriages void on the grounds of public policy, and it was intertwined with notions of Christian marriage and morality, and there was no regard for broader cultural diversity or religious diversity. Over the past 20 years, obviously we litigated, and one of the first cases that came before the court to be able to broadly first recognize the Muslim marriages was Rylands versus Idris. And one of the positive developments was that while marriages were not fully recognized, the case enabled Muslim marital responsibilities to be judicially enforced. Now, this is very important because this might be in the context of marriage and maintenance, etc., and divorce. And we are talking here about inheritance, but the mere fact that the court took steps to recognize the Muslim marital relationship, the Muslim marital responsibility as a broader contract, it gave us rights, which meant that women in particularly could access rights. In 1998, what happened was that it was the Ahmad case. The applicant claimed damages in the High Court for loss of support because her husband died in a car accident. And the challenge that you're sitting with, imagine that you have children and you are destitute and you are now not recognized as a spouse within what they then call or the multilateral motor vehicle accidents, which now today we call the Road Accident Fund, and they could not claim. So the court recognized that parties to a de facto monogamous, and this was also very important, at that point in time, they did not recognize polygamous marriages, should be awarded the same damages as parties to a civil marriage, and also court noted that approaches in this particular matter was inconsistent with the ethos and tolerance of our new democracy. I think it's important that we see here the positive development is that now you will be able to be included as a spouse. In 2004, the Daniels matter, which was one of the cases of the Women's Legal Center, the Constitutional Court decided that a Muslim spouse in a monogamous Muslim marriage has the right to inherit and claim maintenance from her deceased spouse in terms of the Intestate Succession Act and also the maintenance claim. So what does this mean? It obviously means the person left without a will. This has consequences because clearly it's not going to be allocated or distributed in terms of the Islamic principles which were set out by Sheikh Abdul Rauf. But the challenge that we're sitting with in a country where we are a minority and women have historically been disadvantaged, it was important for the Women's Legal Center to ensure that these rights of women, in particularly maintenance rights of women, are seen to once that estate is distributed. Because if the woman wasn't recognized, the estate would have gone completely to the children. And the challenge is, at the end of the day, it means that she's being disinherited from her share and also she can be evicted from her home. So the court attempted to give meaning, and they interpreted spouse to mean also Muslim spouse. However, obviously we are now talking about polygamous matters, and the court also subsequently included polygamous marriages, which is very important. There were many other positive developments, but I think those two acts, which is the Maintenance of Surviving Spouses Act, as well as the Intestate Succession Act, now includes Muslim spouses, which predominantly, I would say, because women in South Africa are disproportionately impacted by a range of issues, which includes Muslim women, they can get a portion of that particular estate and they can claim maintenance. Recently, also in addition to that, when you do have a will, In the case of Musa and others, the challenge that we had was, in that matter, it was a polygamous marriage, but the one partner was married in terms of community of property, and the other one was only married in terms of Muslim marriage. The challenge is that the court, or not the court, the state did not recognize spouse in the Muslim context, and everything went to the wife that was married in community of property. That was challenged also by the Women's Legal Center, and to be able to say that that the recognition should be similar. And the court then read into the provision of 7.3 also that of a wife in a polygamous marriage. So these are all within the context of intestate succession. And if the challenges that we have seen is that if you do not have what they call a usufruct, or you do not include it in your will, the challenge is that they can lose their home, their maintenance, and there are various challenges that women and children go through if the succession planning is not done proper. I also think that within the context of an Islamic will, so in an intestate, or even though it is not in accordance with the Islamic division of estate, at least there is protection for women in South Africa if they are left out of a particular will or there has been no will. If there is a will, one of the challenges that we have seen, and it has come up more and more, and I don't know whether or not Sheikh Abdullah have even, it's a challenge where the distribution is done in a manner and the wife, who is an elderly person, are normally given a share which does not allow her to maintain her lifestyle and that which is required. Because Muslim marriages is still not enforceable, I would not say not recognized because of the recent court case that recognizes Muslim marriages, and it has instructed the state to be able to come up either with a broad legislative framework or incorporate, but they have to do something to be able to ensure that Muslim marriages and or the consequences of such, which is through divorce or in terms of inheritance, are recognized. We need to be able to look at it within the context when they do an Islamic distribution will. The challenge that we always said was, and it might be right and it might be wrong, it's not sufficient. The elder son is not looking after or maintaining the mother or the daughters. And what we have seen is that they have lost their homes through that process because it is not enforceable. It is the law that is tested, and we need to be able to look at how do we enforce that women and children are not disadvantaged, sadly, because of a will that has been drafted in such a manner that does not take into account that it is not an entire system, that takes into account that the elder son must ensure that there is maintenance for the mother, ensure that there is maybe for the children in terms of the Quranic principles. And this is some of the challenges that we are looking at. Cases that have come before us is exactly that, where mothers have come to our offices in terms of an Islamic will, and we are now forced to bring an application in terms of the Maintenance of Surviving Spouses Act against an Islamic distribution will, because the mother or the children are going to sit without a home. And I think we need to be able to look at the distribution of our will and the drafting of our will to be able to ensure that our mothers and children are taken care of in a manner which is enforceable and takes into account the lived reality of South Africa, which means that we do not live in a country where we make the rules, but we do have the freedom of testation to be able to have an Islamic will. But we also have the freedom of testation to ensure that mothers and children within a South African context are taken care of, and we ensure that there's a transformative way of either interpreting or ensuring that they are taken care of. Because if there was enforcement, then I would have said 100% we need to be able to look at distribution of wills. But if we don't have enforcement, the challenge is, what are you going to do if they don't do what is required in terms of that will beyond that which has been allocated? What happens if that son does not look after that mother? What can you do in terms of South African law? Because clearly, if there is non-enforcement, there's nothing you can do other than going to court or to be able to use the state mechanism to start including women and children within that process. There are still many processes. Since 2 years ago, there are a few bills or processes that the state has started to ensure that Muslim marriages broadly are recognized, including the consequences. But the state has to do this by March 2024, which is next year. And we have not seen any broader consultations yet, but we need to ensure that what is required in the Quran and what is required for our mothers and children are reflected in what the state either is going to bring in, or also what the court decides if a case goes to court again, and to ensure that those protections are there. If there are any specific questions, then I will answer, but I think I've taken my 20 minutes.